Hi, everybody, and welcome to Judgment Day, the webcast/podcast, where I go over some of the important judgments from the courts across the country and cases that are going into court, the legal matters that matter to you now. And, we're coming to you through the internet, of course. And the internet has changed our lives. We all know that. And the justice system has been very, very slow to catch up to it. And that's because the internet, as I've talked about many times, can be this wonderful place, freedom of expression, freedom of speech, ideas. We all know about social media, but it is also a place that can cause a lot of irreparable damage to people, to companies, to organizations, to reputations. I've called the internet many times the Wild West because the laws have never really been there to deal with so much of what goes on. And a lot of what goes on is definitely harmful to people. And I deal in my practice, for example, a huge part of my practice with people who come to me because somebody has posted something on the internet about them, whether it's on Twitter. I've had cases where somebody has had a posting on social media, and within 24 hours they've lost their job on one posting. And a very recent case that just came out has dealt with a lot of these issues. And what happens a lot in the world of litigation and the world of law is judges can create new law. We call, for example, new torts. And that is what's happened here in Ontario, dealing with the internet and dealing with, in the context of a person who, we won't get into her story per se, a serial defamer. But the case is so important because Justice Corbett here in Ontario created a new tort, which somebody could actually bring, called the tort of online or internet harassment. And we're going to go through the case. We're going to go through the lawyer who argued the case and brought this to the attention of this particular judge, because and why this ruling is so important is that right now it's here in Ontario, but don't be surprised if you see it applied across the country. So let's talk about this case. Let's bring in the lawyer who argued it in the Ontario Superior Court. And I guess I'll do a mea culpa here. My former law partner at another law firm, and someone I have the greatest respect for, is Gary Caplan. And Gary, welcome to Judgment Day, and thank you for joining me today.
Hi, Lorne. Thank you very much for having me on. It's a privilege, and I thank you for it.
This case, Gary, that you argued is so important because why don't we set the table here so we can understand what. And again, I don't want to go to the facts of the specific case, but certainly Justice Corbett, in going through what he talked about the internet. I just want to read one thing because he sets this up, and he said that freedom of speech and the law of defamation has developed over the centuries to balance what he says the importance of preserving open public discourse, advancing the search for truth, protecting reputations, all of those things. And then he says these words: the internet has cast that balance into disarray. And that's something you obviously agree with.
Yeah, totally. And what's so unique about the creation of this new tort is that it tries to address a gap or a hole in the law, and it sort of brings the law of defamation up to what is the law of harassment.
Right. And just so we can understand why the harassment aspect is so important. And there will be people who will be watching this who would say, I probably have been the victim of, quote, online harassment. Justice Corbett, in the decision, he talks about the prevalence of online harassment. He described it, I think his words, Gary, was shocking. 31% of, if I remember correctly, what he referred to of social media users in Canada were harassed. And I think that's back in what, 2016, was it?
That's right. That's right, Lorne. And you've hit the nail on the head. And let me begin by making this distinction. You can harass somebody and not defame them. You can defame somebody and not harass them, or you can do both.
Right.
And what's important about this decision is this was a case of both. And the court was faced with a problem with somebody who was engaged in both kind of conduct. And here the law of defamation just didn't quite provide the plaintiffs with the remedy they needed.
So many people who are, we'll call it the victim of internet or online harassment. The pushback to them, Gary, would always be from a legal point of view. And again, I sort of touched on it in that first paragraph by Justice Corbett when he talks about freedom of expression and the balance. People will say, and they say this all the time, is that we want freedom of expression. That's protected in the charter. That's a charter right under Section 2B of our charter. And that if you start creating these types of torts, you have the potential, if you will, of basically stifling free speech. That would be the argument and the pushback.
That's exactly right. But where the problem really happens is, Lorne, let's take an example of I want to harass you, but I don't want to defame you. But what I might do is I might defame a family member of yours with the intention of harassing you or trying to intimidate you, say in your role as a lawyer. And there's an example of where the law of defamation really doesn't work, because I'm defaming somebody, I'm defaming person A, but in so doing, I'm really harassing, intimidating, or trying to influence person B. And you see this more and more on the internet. It's just rampant. And the statistic you mentioned actually comes out of social science research, which shockingly has found a high degree of internet defamation, invasion of privacy, use of private and confidential information. It comes in so many forms, including cyberbullying.
Right.
And just applying a definition to conduct is in and of itself a challenge for lawyers who ask themselves, okay, is this bullying? Is this harassment? Is this defamation? Is it an invasion of privacy? What are the boundaries between all of these? That's where the sort of grand tort of harassment might come in to rescue this kind of imbroglio of conduct and definition.
Right. And you see, we always use as lawyers the expression slippery slope, because, and I mentioned about freedom of expression before, we want people and we want the internet to be a place where you can go on and you can give your opinions, and you can even give very harsh opinions, and you can criticize. But that line that you talk about, where you may enter into defamation, where you may enter into an invasion of privacy, or now you go into this more objectionable conduct, if you will, where you start hearing the words cyber stalking, for example, or cyber bullying.
Right.
And then you top that off with people who hide behind cloaks of anonymity where they don't even have their name. The recipients of these messages and these publications would have no remedy.
And it is the anonymity of the internet that poses the greatest risk to discourse. It's bad enough if you want to either intentionally or otherwise defame or harass somebody, fine. But then to add another layer by hiding behind some username or some pseudonym or alias or fake name makes it very difficult for the victim to find out who it was. And I can tell you, Lorne, that the cost to the average citizen of trying to retain a lawyer or trying to retain a cyber detective or trying to bring some legal remedy is it's gargantuan. It is so expensive and time
Yep.
consuming that your average citizen is literally left without remedies. And going to the police and trying to use the criminal code provisions
Yeah. It's
under
just
the code, the police will either say it's a civil matter, go retain a civil lawyer, or they're so stretched for resources. They have, physical crime to deal with, large frauds,
right.
personal safety issues, that this sort of goes to the bottom and is not a priority.
So in this case, you argued and you referred on some American case law to create this new tort that we now have in the province of Ontario, internet harassment. And let's go through the elements of this tort uh, because and what I'll be saying at the end of it is good for you, Gary. It no. I mean, it is very, very important, but I'm wondering who's going to be able to meet this test. So let's look at the wording that Justice Corbett has set out where he adopted your argument. One, the defendant maliciously or recklessly engaged in communication conduct so outrageous in character, duration, and extreme in degree so as to go beyond all possible bounds of decency and tolerance. Let's stop before we go to the next element.
Right. And the reason why those words were selected was because intuitively, you know that if somebody is annoyed, you don't want to have a floodgate of lawsuits flow from that. So
Right.
it had to go to such an extreme
Right.
to constitute the tort. Simple inconvenience, annoyance is not going to cut it. You really have to show that the perpetrator was malicious, was reckless, and that the communications conduct was outrageous.
Outrageous is the word.
Outrageous was the word he used, and
Yeah.
part of that is lifted from the American literature, but it's also found in some statutes that are found in other Canadian provinces, not Ontario, which
Okay.
does not have a statute.
The other part where it says outrageous in duration, and that, well, what does that mean? Could it be like one posting, and it's got to be more than one? It's got to be more than 10? You can see how that may be litigated down the road to say, well, no, the case that Mr. Caplan argued, that person had over 500 postings or whatever. So
This case actually has more than I think the last count was almost 11,000
wow.
URLs. The judgment, which we hope to get issued shortly, contains a USB with single line URLs that amount to more than 2,500 pages.
Oh my goodness. So
So
there you go. I mean, and if that case is going to be the landmark, if you will, it may be hard. Let's go to the second element. So you've got this outrageous in character, duration, extreme in degree. Then it says the communication conduct was done with the intent. So there's an intent that's put in here to cause fear, anxiety, emotional upset, or impugn the dignity of the plaintiff. And again, it's not going to be that easy to even meet that standard as well.
exactly. And the whole idea here was, unlike defamation, which lowers the person's reputation in the eyes of the public, um, this is to cause fear and intimidation or anxiety. And you actually have to have, as part of the tort, the perpetrator has to have intended to do that, and the plaintiff victim has to actually suffer it.
Right. And that's some damages. You have to be able to show that you suffered. Unlike in defamation, where damages are presumed, you actually have to show that you've now suffered. And I guess what we're talking about is we're talking about psychological damage. We could be talking about financial damage.
Exactly. In the case which, and you'll see this in the judgment if people read it, is that there was a concern that when somebody is, for example, singled out as a pedophile, that could invite online vigilantes and offline vigilantes, if they can locate you, to take out, there may be a risk of physical harm. It's not just reputational, it's actual fear of harm. You can harass somebody and theoretically they could go home and lock the door and avoid being bullied outside. The internet is inside your house. You're being harassed inside your house.
Gary, I was talking before about the freedom of expression aspect. And it's interesting that this case comes out and it talks about dealing with that type of alleged serial defamer. At the opposite end, we have a law in Ontario called the anti-slap legislation, where we want to stop people from bringing lawsuits against people who are expressing themselves on the internet and in other places, so they don't fall to what we call libel chills, because we don't want to stifle freedom of expression. And that is this continuum that we deal with. We have both of these now laws, the internet harassment to stop it, and then the anti-slap to stop people from trying to stop free speech. And that's what makes this such a complicated area, and why we always say we have to look at each case on its own facts.
That's exactly right, Lorne. And like everything else in law, what the courts try and establish is a binary of countervailing principles. And every case presents another shift in that kind of fulcrum or balance between the countervailing principles. And, the Canadian courts and other courts have struggled in the law of defamation with creating, other defenses such as responsible communication and other things. When you apply that to the internet, it becomes even more complex. And the law is really, I think, domestic law of defamation is really in trouble, because you can be forum shopping.
Yeah.
If you have a defamatory or a harassing series of communications that originate in country A, but the victim is in country B, what court do you sue? What police call?
No, I was very fortunate, Gary. As you may recall, back in 2012, I got to argue in the Supreme Court of Canada about that issue. And so people here in Canada, in Ontario, know that if you do get defamed by somebody in Australia, you do have the right to bring the action here in Ontario. However, you're correct in saying that person who's sitting in his or her basement in Australia defaming you here in Ontario, and you may be able to get to court and you may be able to get your order, but how hard is that going to be to enforce? And then on top of that, I know you have experience in this, people who use these websites in the United States, these third-party websites to defame people here, and you can't do anything because they won't even recognize our judgments.
Right. So one of the problems is where to sue, assuming you can figure out who to sue given an anonymity. But even if you do that, you spend the time, you spend the money, what's your remedy?
Yeah.
So traditionally, as we all know, in the law of defamation, your remedy is one of damages. And only rarely do you get a permanent injunction. What people want now is they want takedown orders. They want the stuff removed from the internet. And that has its challenges because of interjurisdictional differences in laws. As you know, in the United States, intermediaries are protected by a whole series of laws. And you can't go forum shopping to enforce a libel judgment that you obtained in England, for example, in the United States, because that's protected by what's the Americans call the Speech Act. So you have those problems. Now, what Justice Corbett did in this case was something that I think is very unique. And what he did was he granted an order in circumstances where the defendant had no money, to respond to a judgment, had shown conduct which made it clear the defendant was not going to listen to any court order. So what do you do if you're a judge? Well, Justice Corbett granted to the plaintiff victims a property interest in the postings themselves and in the credentials of the poster. In other words, my clients now own the property of the post. And with the ownership of that property, we may be able to use the terms of service of each third-party website to take them down.
I was going to say, yeah, that's right. So you've got a permanent injunction for what it may be worth.
Right.
Although he did, am I correct in saying he didn't go right to the end and order her totally off the internet? But
we thought about that, and he thought about that. The problem, Lorne, really is one of enforcement. You sneak out of your house, you go to an internet cafe.
That's the whole problem.
That's the problem. Like
Wild West. I started this by saying it's the Wild West. Well, Gary, listen, I'm going to tell everybody the name of the case is ATAS, ATAS. You could go on, you Google Canley. Canley is the website here in Ontario, and in fact across Canada, where you can just look up a case and you'll see it. Recent decision, Justice Corbett, and it is really interesting. And we'll see, I guess the key thing now, Gary, will be how many of these internet harassment cases will be. My guess is very, very few, because as we said, that test is pretty stringent and it's going to be hard to meet. But good for you in creating, in part in creating it, because I think it is necessary. There's absolutely no doubt that we need the law to start evolving and start catching up to this medium that we're on right now and the potential harm that it can do. So thanks for joining me, my friend. And
thank you, Lorne. All the best.
And we'll talk soon.
Bye now.
Gary Caplan. And it is an important decision to read. And I was mentioning with Gary, talking about the anti-slap legislation. You've heard that word before, and because people will email me, and I've had people talk about this with me before. And indeed, in my practice, I act for people on both sides of the defamation issue. I act for people who are being alleged to have defamed someone else, not just people who allege are being defamed. And it is a very interesting balance, because there is argument to be made that we do want to keep the internet a place where you can give your opinion, where you can actually come out and be critical. We know politicians face that type of life all the time. We criticize their decisions, and you don't want a politician or people in high profile to just be handing out lawsuits to stop people from speaking. So that's different. That's talking about speech and publications that are in the public interest. That's very important. When you get to cyberbullying, when you get to the real vile internet communications, where you take and you create and you basically just put false information out there about someone, about their business, about their family, whatever, with the sole purpose of wanting to just destroy their reputation for whatever reason you might want to do it. That's different. And that's where we have this incredible balance. And, I pick up my phone, somebody calls me and says, Lorne, I need you to help me. I got defamed. Somebody just wrote something online about me. I want, and you go, well, what is it, and is it true, and what's happened? And you hear people, and you can see that within literally, not figuratively, literally hours sometimes, of how that has affected them. Because the important thing to always remember about reputation, it is that it's 100% personal. The injury to someone's reputation, to injury to yours, injury to mine, is all different. It's not like if you slip and fall on a city sidewalk because they forgot to put salt down on the ice and you break your arm and you need your arm for work. Really easy to find out what that may be worth in the courts or what your damages are, but reputation is different. For some people, they can be hit with so many different internet, what we would call harassing or bullying postings, and they'll be okay. Another person, it could just take one and it could damage them irreparably. And that's why it's so important for the law to really catch up to what we have out there right now. And I can tell you, we use the word catch up, but it's not even close yet. And that's why cases like Gary Caplan's case that he just argued and the judgment that came out, where we now have a new tort in this province, while it may be very, very difficult to meet those elements, it's a good first step. And we'll see where things evolve from there. All right. That, my friends, wraps up this edition of Judgment Day. I want to thank you again for joining me. And of course, if you have any comments at all, I'm not on social media, but you can send me to my email, lhonickman@btlegal.ca. I'm happy to hear what you have to say. And use the internet. Use it properly. And that would be the best last piece of advice that I could give you. I'm Lorne Honickman. Thanks for joining me, and I'll see you on the next Judgment Day.